Start. The foundation for this reference relating to the interpretation of section 123 of the Representation of the People Act, 1951 to a bench of 7 judges has its origins in 3 decisions of this court. Stop. While hearing the appeal against the decision of the Bombay High Court, a bench of 3 learned judges expressed the view that the content, scope and what constitutes a corrupt practice under subsections 3 of section 123 of the Representation of the People Act, 1951 needs to be clearly and authoritatively laid down to avoid a miscarriage of justice in interpreting corrupt practice. Stop. The bench was of opinion that the appeal requires to be heard and decided by a larger bench of 5 judges of this court on 3 specific questions of law. Stop para. In appeal before this court, the Constitution bench noticed an anomalous situation arising out of an amendment to section 123 of the Act in 1961, inasmuch as it appeared that a corrupt practice for the purposes of the Act prior to the amendment could cease to be a corrupt practice after the amendment. Stop. On the one hand, the deletion of certain words from the subsection widened the scope of the subsection, while the addition of a word seemingly had the opposite effect. Stop para. Since there are certain other significant observations made in the order passed by the Constitution bench, it would be more appropriate to quote the relevant text of the order. Stop. Thereafter, when Abhiram Singh was taken up for consideration by the Constitution bench, an order was made that since one of the questions involved in the present appeal is already referred to a larger bench of 7 judges, we think it appropriate to refer this appeal to a limited extent regarding interpretation of subsection 3 of section 123 of the 1951 Act to a larger bench of 7 judges. Stop para. It is under these circumstances that these appeals are before us on a limited question of the interpretation of subsection 3 of section 123 of the Act. Stop. In this case, the Constitution bench held that an appeal to the electorate on a ground personal to the candidate relating to his language attracts the prohibition of a corrupt practice under section 100 read with section 123 of the Act. Stop. The Constitution bench made a reference to subsection 3 of section 123 of the Act in rather broad terms. Stop. The Constitution bench read into section 123 of the Act the concept of a secular democracy and the purity of elections, which must be free of unhealthy practices. Stop para. It is quite clear from a reading of the above passages that the concern of Parliament in enacting section 123 of the Act was to provide a check on the undesirable development of appeals to religion, race, caste, community or language of any candidate. Stop. Therefore, to maintain the sanctity of the democracy process and to avoid vitiating the secular atmosphere of democratic life, an appeal to any of the factors would void the election of the candidate committing the corrupt practice. However, it must be noted that the party made no reference to the decision in that case. Stop. Significantly, this decision did not make any reference to the narrow interpretation given to Section 123 of the Act or to broad interpretation given to the same provision a few years earlier. Stop. Finally, this court held that the use of the word his in subsection 3 of section 123 of the Act must have significance and it cannot be ignored or equated with the word any to bring within the net of subsection 3 any appeal in which there is a reference to religion. Stop.